Good morning. Welcome to the 2020 edition of the Copenbarger Copenbarger Client Seminars. Because of the event that we're dealing with right now, the coronavirus epidemic, we are reducing our client seminars to a video presentation so that they can be made available to all of you who are our clients. As most of you know, through the years, every year we try to keep you informed and up to date on changes in the law and other things that we believe would be important for our clients to be aware of. This year, in spite of the circumstances that we're facing, is no exception. Copenbarger Copenbarger is going to be there for you to meet your needs. As for years I have said, if an attorney is not there when you need them, you don't need them. And so Copenbarger Copenbarger is going to be here for you to meet your needs regardless of the circumstances that our society faces. Let me introduce to you the important people at Copenbarger Copenbarger that are there to serve you. First of all, I'm Lloyd Copenbarger. I founded this firm over 40 years ago, and it has been my great privilege and pleasure to represent many of you over the years and be there for you and your family when you had needs. But we also have an absolutely superb team of attorneys who have the skills and capabilities to provide for any need that you might have in the estate planning, business planning area of the law. First of all, James Kosaroff. James has been a member of the Copenbarger Copenbarger team for many years. James is a state board certified specialist in trust, probate, and estate planning law. He is also a tax attorney, having received his master's degree in tax and law. He heads up our trust administration department. That's the department that helps people deal with the aftermath of a disability of a loved one or the death of a loved one. Probably the most difficult area of practice we have, and James does it ably. Also, there is the man that I consider to be the best attorney I've ever produced, Larry Copenbarger. Larry also has a master's degree in tax and law, and Larry is expecting to receive his state board certification of specialization in trust, probate, and estate planning law at any time in the near future. And then there is the CPA attorney who is part of our business law practice, Sunny Boren. Sunny is a CPA. She also is an attorney. She works in not-for-profit law, and she works in charitable organizations. Dale Anderson is the go-to guy for many different areas in the practice. He is the attorney who handles litigation matters when there is a requirement to have an attorney who is skilled in court matters. He also helps with estate planning, and he helps with trust administration. Stephanie Delaney is the newest member of our firm in the Orange County office. Stephanie helps James in the trust administration area and helps people deal with the aftermath of the disability of a loved one or the death of a loved one. Robert Giuliano is the attorney who is in charge of our office in Temecula. Robert also is a state board certified specialist in trust, probate, and estate planning law. He also has a master's degree in tax in law. He is a very, very capable attorney, and we are blessed to have him serving the North San Diego area and the area of Riverside County that is in the Temecula area. Victoria Horwich is the attorney who represents us in the San Jose office. Now, the San Jose office not only has Victoria serving it, but also myself, Larry, and James also spend time in that office because it is a very vital part of the representation of Copenbarger Copenbarger in the state of California. But Victoria is a very capable young lady. We have great ideas for her future as part of the Copenbarger Copenbarger team. And then we have, as an attorney who is of counsel, that means he's not part of the Copenbarger Copenbarger firm, but he is there to provide assistance to us when that is required, and that is James Humphreys. Mr. Humphreys has been in practice for many, many years and is a very capable addition to provide guidance and wisdom to our attorneys. All of these attorneys are part of our team. Many of them you'll be hearing from later in our presentation today, presenting specific areas of interest to you. I also want to take a moment to introduce you to the people who actually make the firm of Copenbarger and Copenbarger work. Our dedicated, loyal staff of paralegals and legal assistants who help the attorneys provide the services to you that provide the protection to you and your families. I can't take the time to introduce them all to you personally, but I know that if they had an opportunity, they would give you their personal expression of appreciation for the privilege of serving you. Copenbarger Copenbarger has offices in a number of different locations throughout the state of California. South Coast Metro, which is our main office here in the South Coast Metro area of Orange County. We also have an office in San Jose. We've had the office in San Jose almost 40 years. We have an office in Pasadena. That office has also been an office of Copenbarger Copenbarger for almost 40 years. We recently acquired the firm of Robert Giuliano in Temecula. Robert had been in practice in Temecula for many years and is a very well-known attorney in that community. And we commend that office to any of our clients and friends who are in the Riverside County in the North San Diego County area. We also have office capability in San Diego, Capitola, and Sacramento. Those are offices that we have where we can meet clients in those areas when there is a need to meet with the clients. But probably the most exciting thing that is happening with Copenbarger and Copenbarger is several years ago, I saw the time coming when it would be difficult for those of you who have been my clients for many years to come into our offices. As we get older, the ability to travel becomes more and more restricted. And I didn't want us to ever have a time when a client would have to no longer use our services because we were not available to them. And so we started developing the capability to meet with you by virtual reality through Zoom or through Skype or some similar device where we could communicate you on video, where you would be able to see us, we would be able to see you and communicate and take care of your needs. We had intended to open that to the public and to our clients this fall. Because of the coronavirus panic and epidemic, we are exercising that capability immediately. And we have already used it several times over the past week or so. And I am very pleased to announce to you that it has proven to be a very effective way to serve clients from the safety and security of their home, but with us being able to provide the high quality of service as attorneys that are absolutely essential for the Copenbarger and Copenbarger firm to properly serve our clients. At this time, I want to introduce to you one of the members of our staff, Dale Anderson. Dale is going to be coming to talk to you about the foundations of estate planning. I realize that many of you who are watching this presentation are not members of the Copenbarger and Copenbarger client family. And I realize that some of the things that we're going to be talking about will be areas that you have not had past opportunity to receive information about. And so I've asked Dale to come forward and give you a brief overview of the documents and the options that are available to you as part of the planning process. As many of you are aware, we try to recognize the divine's influence over the affairs of life. And so I've asked Dale to open our session with a simple word of prayer, asking God's blessing on our time together and on the efforts that we're going to be expending today to try to be of help to you. Dale?
As Lloyd said, what I would like to do is just kind of go over some of the basics of estate planning. And as Lloyd said, if you're one of our clients, these are documents that I'm going to remind you that you already have in your estate plan and perhaps forgot because it may have been some years since you had these done. So I want to review a little bit about what you have. And if you are not our current clients, this will give you a good foundation of what is needed in everybody's estate plan. All right. First off, we'll talk about what is an estate plan. Then we'll talk about what is a power of attorney, what is a will, what is a living trust. You've probably heard the term, but now I want to go over a little bit what exactly is a living trust, what is involved in the living trust, and what are its advantages. As we begin talking about an estate plan, I guess the first question is, what is an estate? And the short answer for what is an estate is basically everything that we have. I like to use this illustration. I've been to the Philippines a few times, and there's one thing missing from the Philippines that I've never seen there that you see all over here, and that's self-storage units. Why is it? Because, we get 3-car garages and we fill those up, and then we buy self-storage units to store our stuff. But all of that stuff, all of the toys, all of the things that you've accumulated over your life is your estate. And estate planning is helping you determine what happens to that once you're gone. Who gets the benefit from it? Who's in control of it? And when do they get to have the benefit? So when we talk about an estate plan, there's a few things that we need to cover first, because we're talking about protections. Everything we do at Copenbarger and Copenbarger is to help provide protections for you and your family and your legacy. So when we talk about protection, what's the very first thing we want to protect? What's the number one thing people want to have control of and protection of? Well, that's pretty simple. It's ourselves, right? We would like to be in control and feel like we have some say over what happens to us, what kind of treatment we have, where we get therapy. And so the number one thing we want is protection for ourselves. So can we provide for that protection when you no longer can make those decisions? And the short answer is yes. Part of the estate plan you have, if you've had your plan done by Copenbarger and Copenbarger, and if you haven't had it done by us, one thing you absolutely need is an advanced healthcare directive power of attorney. And that is a document through which you can name someone to make those healthcare decisions for you when you can no longer make them yourselves. Without that kind of direction, what happens? If you become incapacitated and cannot make those decisions, a lot of people think, well, naturally my spouse can make those decisions for you. Unfortunately, that's not necessarily the case. The recently passed law that went into effect in 2004, effectively known as HIPAA, has said that your medical information is basically yours. And the medical care providers can only share that with who you say they can share it with. So unless you specifically name your spouse, there's a good chance the healthcare provider would not even allow your spouse to make that decision for you. So without that, what's your options? Then you'd have to go to court and have somebody named as your conservator. And of course, that can be a very costly expense. So we here at Copenbarger and Copenbarger want to provide protection for that so that you can name that person ahead of time through your healthcare power of attorney. All right, so the advanced healthcare directive part of it allows you to tell your healthcare power of attorney what decisions to make in certain circumstances. So that can protect you when you're alive but not well. But also if you're alive but not well, who can make those decisions for you as to your financial matters? You can also do that through what we call a durable power of attorney. And a durable power of attorney basically names someone to speak as if they were you. I like to use this illustration. I always ask people, what exactly is an attorney? All right, a lot of people say, well, you're an attorney. Well, we are an attorney at law. Because an attorney basically is someone who speaks on your behalf as if they were you. Now, attorneys at law, we speak for you as to what? As to legal matters. But you can name someone as your power of attorney as to any kind of matters. And so as part of your estate plan, we give you a document known as a durable power of attorney through which you name someone as your attorney, someone to speak on your behalf as to financial matters. And this is pretty much a God power, we like to call it. For example, if I took out my blank check and I handed it to you, what would you be in control of? Basically, only what's in that particular checking account, right? However, if we give you a financial power of attorney, what are you in charge of? Everything. So part of every estate plan should have a good general durable power of attorney. What happens if you're no longer alive and therefore not well? Now what do you have? What do you need to protect yourself? What do you need? A will or a trust? I know you've probably heard different things. I need a will, I need a trust, I need both. So what exactly is a will? A will is a document that allows the court to transfer property from one name to another. And I know a lot of people say, well, If I have a will, therefore I'm going to avoid probate. Well, if you have a will, you've guaranteed you're going through probate. And I just want you also to know that even if you've never gone to an attorney or you've never written one out yourself, guess what? You already have a will. It may not be one that you wrote for yourself, but it's one the state of California wrote for you. Now, are you sure they understand exactly what you want? Sometimes they get it right, but there are a lot of times they don't get it right. So if you want to make sure that you retain some control over what happens to your legacy, your estate when you're gone, you need to have your own will. So what does a will do? A will allows the court, through the probate process, to take your property from your name and transfer it to another. So what is the probate process? Well, the probate process is both expensive and lengthy. Expensive because there's lots of fees involved with it. And we would say, let's just say an average for a estate of about $1 million. You're looking at attorney fees, which are set by statute, of at least $13,000. Then if you have an executor, they're also entitled to the exact same fees. Then you've got the court costs and the fees involved. So easily with a $1 million estate, you're looking at $26,000, $30,000, $35,000 in probate costs. But the good news is you can avoid all of that expense and delays through the living trust. So what is a living trust? We like to use this example here at Copenbarger and Copenbarger. Remember those little red wagons kids used to play with? I think they're called radio flyer wagons. They'd take all their toys and they'd put it in the wagon, and then they'd pull it around the wagon wherever they go, and they'll stop and play with their toys, or they'll let their friends play with their toys. But they're in control of the wagon, right? That little red wagon is, in essence, your trust. A trust is simply a vehicle to hold all of your toys and allow you to pull that wagon wherever you go. On the handle of that wagon is a set of instructions that you set up saying, if I drop the handle of the wagon, who picks it up? And then once they pick it up, what can they do with what's in the wagon? So that's a little example of what a living trust is. It's a vehicle to hold your toys and to allow you to maintain some control over what happens, what's in the wagon. Now, while you're alive and not well, it allows somebody to access the wagon to take care of you. And when you're gone, it tells your successor trustee what they can do with what's in the wagon and who to give it to. Now, it's important to set up the wagon, but almost equally as important is to make sure that all of your toys get into the wagon. And that's what we call funding. And there will be some discussions later about what steps you need to take to make sure you put all your toys into the wagon to take care of it. So if you're part of Copenbarger and Copenbarger, each one of these documents that I just established are part of your estate plan. You already have your healthcare power of attorneys. You have your financial power of attorney. You also have a will. Now let me just clarify one thing right off the bat. You say, if I've got a trust, why do I then need a will? The will is what we call a pour-over will. Let me explain what that means. Remember I told you that the wagon is only good for what toys you put into the wagon? Let's say for whatever reason you forgot to put one of your toys into the wagon. What the will does, it says, take everything that I forgot to put in the wagon and pour it over into the wagon. Thus we get the term pour-over will. That way all of your assets, all of your toys, will be distributed pursuant to that set of instructions that you set up on your trust. So as part of your estate plan, remember you should always have a healthcare power of attorney, you should have a financial power of attorney, you should have your trust, that wagon, and you should have the will that tells everybody, if I forgot to put something into the wagon, let's pour it over into it. And let me add one more thing for those of you who maybe have children. When they turn 18, guess what? You no longer have the legal authority to make those healthcare decisions for them. So if you have children who have just turned 18 or 19 or 20, they also need a healthcare power of attorney. Because once they turn that magical age of 18, you as a parent have lost your legal authority to make healthcare decisions for them. So if you have children who have just turned 18, 19, or 20, or grandkids in that age, you need to let them know and encourage them to come and see us so that they can have this healthcare power of attorney provided for them. So with that as a summary, those of you who are our clients, those are the documents you have in your portfolio right now. And those of you who are not, those are the essential documents needed for every estate plan.
Thank you very much, Dale. I want to emphasize the importance of what Dale has just said. Many times, and as the years pass after you have gotten a comprehensive estate plan through Copenbarger Copenbarger, you forget the degree of protection that plan provides you. And so it's always good for you to refresh your memory and to advise the people that you would rely on if you couldn't act for yourself of the powers that you've given them to take care of you when you can no longer take care of yourself. One of the things I want to talk about that is very important for those of you who are existing clients of Copenbarger Copenbarger is to make sure that your documents are kept current and that any potential problems within your estate planning documents have been dealt with. One of the probably most common mistakes that get made is in our hurry through our existing life and our existing activities is we forget to keep our trust properly funded. And I've asked Robert to come up and talk to you for a few minutes about how you fund your trust and how you make certain that your trust is continually updated by properly funding it as you acquire assets and dispose of assets. Robert?
Thank you, Lloyd. This is a very important subject in the sense that you have gone through a great deal of planning to create a wonderful trust with Copenbarger Copenbarger. And when we created the trust for you, we assisted you with retitling assets that needed to be owned by the trust, and that term is called funding. Now, funding the trust is critical not only at the beginning of creating your trust document, but also it's a responsibility that you have in maintaining assets that you acquire after you created your trust that require to be titled by the trust for you to make sure that they are correctly owned, titled by the trust. Now, for example, if you buy another piece of real estate, please make sure that the mortgage process, the escrow company, and so forth, that they take title in the name of your revocable trust. For example, if you open a new bank account, we would like for you to make sure that the bank account is open in the name of your revocable trust. But let me ask you, do you know what happens when you leave an asset that should have been in the trust out of the trust? And the problem with that is that that asset that is not controlled by the trust may be subject to that horrendous process that we try to avoid called probate. And therefore, a lot of times when we meet people that are not Copenbarger Copenbarger clients, that they come in to see us and they have a trust and they're sitting in front of us and wonder whether still what had to go through probate is because they never funded correctly, never put their assets in the name of their trust. So how do you do it? I'll tell you how I like to keep my trust updated, and that is that every year around April, what is it that we're faced with? Well, we have to get ready for taxes. One of the things we have to do is we have to take a look at all the assets that we have for the year, report them to the CPA. This is a great opportunity for you to look at all of the accounts that you have, all your brokerage accounts, bank accounts, and titling, for example, of your real estate. You may have acquired a timeshare, and this is the best time to maintain yourself current by reviewing the list of assets that you own, making sure that these assets are correctly funded in your trust. Now, you may or may not remember, but we gave you instructions as to how to keep your trust funded. Most law firms do not do that. Why did we do it? Because we know that as we go through life, things happen. We get lackadaisical in taking care of some of the things that we did maybe several years ago, and therefore you may not remember how to take title to some of the assets to put them correctly to the trust. And that's what the funding instructions that we gave you do. Go back and look at that document. It will tell you how to correctly title bank accounts. It will tell you how to correctly title real estate. It's a tool that we gave you. And more important, if you have any questions, if you have any concerns to some of the assets that you may not understand if they're correctly titled in a trust, give us a call. Our job is to help you. And remember, any asset that is outside the trust that should have been titled in the name of the trust will go through that process that we always want to avoid, called probate. The next item that I want to discuss is another one of my favorites. And obviously, if we did the trust for you, we can almost assure you there's going to be a very correct trust and an expert trust created perfectly with all your requirements. But let me kind of give you an idea of what happens when non-Copenbarger and Copenbarger clients come in to see us, and they present us with one of their trusts that was created by another law firm that is not an expert in creating trusts. Did you know that there are probably about 15, 20 types of revocable trusts? Did you know that just because the document is titled trust, that it may not be the right type of document for you? And the example that I give is that if I'm going to race in the Indy 500, would I be driving a Humvee? What if I'm going to go four-wheel driving? Am I going to four-wheel drive in a Maserati? Of course not. Having the right type of trust is important. James talked about asset protection, various types of AB provisions. These are things that are critical. It's important for every family to determine whether you have the right kind of trust for the job. Again, you don't want to wear the wrong pair of shoes to do high heels for running, for example. You have to be careful what you have to make sure you have the right kind of trust. Other things that we see in a trust that is not properly drafted is the following. A lot of times when events happen in life that prevent you to have the ability to make decisions, you became disabled, you don't have the ability to say yes, you don't have the ability to take care or make the decisions that you have to give so that your family can take better care of you. The trust needs authority to have been vested between, let's say, a husband and a wife to be able to handle some of these emergencies. And some of those are possibly having the ability to try to protect assets and enter into the advanced planning that Lloyd talked about with reference to qualifying for Medi-Cal in California. It's important that the trusts have the authority so that in case of incapacity, that your loved ones have the ability then to proceed with the advanced planning that we provide for you. Another one, this is one of my favorites. Last month, I reviewed a trust, and this is what the distribution was. The trust said, I leave everything to my heirs. Now, I ask you, what is wrong with that statement? Heirs, who were they? Your cousin in Louisiana or the gold digger up in Nevada? Who were they? So when I asked them to who prepared the trust, obviously it was not one of our trusts, but having the distribution be very specific is important because the distribution paragraphs in your document are probably the heart of your document, and they have to be very specific, or else who do you think we have to go to in order to get a discrepancy or an ambiguity cleared up? We might have to go to the court. That's something that we do not want to do. Next one. We want to make sure that the successor manager of your trust, called the successor trustee, is the correct and proper successor trustee at the time that you are looking at least to evaluate whether you have the right trustees. The reason that I'm saying this is because maybe 10 years ago, you named Uncle Freddie to be the trustee, and now Uncle Freddie, maybe he is incompetent, or maybe Uncle Freddie is spending a lot of time down at the racetrack at Del Mar. You need to make sure that you review who your successor managers are, because they're the ones that are going to step in to your shoes when you either become incapacitated or after you die. So it's important that you have the proper successor trustees named in your documents. Another one, I know does not apply to any of you, but I'm going to say it anyway. You know what that is? None of your children are ever going to fight after you die, right? Well, guess what? Yes, beneficiaries, children do argue do fight, sometimes even though you may have left the trust distribution equally, a lot of times there's always one child perhaps that decides that maybe they were dad's favorite or maybe they were mom's favorite and they should have been left with more. So California has a law that basically says that if you contest the trust and you don't have probable cause for contesting the trust, that the courts will basically say to you, you're going to be responsible for paying for all the legal fees, you're going to be responsible for paying the court costs, and the court may also disinherit you. So in the Copenbarger and Copenbarger Trust, we go to great lengths. We have the proper contest clauses, and also we have some very direct instructions where we then have you authorize your successor trustee with the ability to defend the trust. And also you allow our firm, Copenbarger and Copenbarger, to interpret your trust. If we prepared your trust, who do you think is better prepared and understand what the trust really says? We are. And therefore, we will interpret what the trust says.
Thank you, Robert. I think what Robert has said is probably the best bow that we can put on this package that we call the client seminar. The only thing I would add to what Robert said is remember, the only thing that's more expensive than having a specialist do your legal work is having someone who's not a specialist do your legal work. And people don't understand that what you know and what you don't know have very real consequences in this area of life and in this area of the law. And so I encourage you to take the time to review your documents carefully, even though we prepared them for you. As life unfolds, sometimes the circumstances of life make what you have provided in the past no longer appropriate for the future. One more thing I want to talk about before I have Dale Anderson and James Kosteroff come up to talk to you about trust administration is I want to talk to you about a program that we've had as a part of Copenbarger and Copenbarger now for 20 years. And it has been a program that when I originally started, my colleagues in the law told me that it would break me. I told them that I didn't believe it would because my clients are people who don't take advantage of us and don't take advantage of our firm. And that program is something called the Access Program. And what that program does is for those people who want to have a special relationship with Copenbarger and Copenbarger, it gives them special access and special benefits. For example, it allows them to make unlimited calls to talk to our office without any charge. Normally, when someone calls the office, the clock starts running and we charge that person based on our hourly rate for the time they're on the telephone with us. Access members don't have to worry about any charges that would arise from telephone calls. It also allows them to come in and meet with us annually for at least 2 hours if they choose to, without any charge for that consultation. Again, that's a value of, depending on the attorney and the attorney's hourly rate, that can range anywhere from $500 to $1,000, depending on the attorney who you're working with. And then it also provides a benefit when the time comes that you need your estate assisted because of disability or because of death. The first $1,000 of attorney's fees involved in a trust administration or the implementation of a disability is covered under the Access Program as part of that program. Many of you who are listening to this are already members of Access. In the past, I limited the number of Access clients to 2,500 because I did not want to be in a position where we were expanding our services to more people than we could properly and adequately provide those services to. Because we've grown and because we now have several mature attorneys available to help you, we are making this program available to more people. And if you would have an interest in becoming a part of the Access program and getting the benefits of the Access program, then be sure and call our 800 number, 1-800-244-8814, and talk to Kara. Kara can tell you what the cost of Access is and can tell you how to join that program if you desire to be a part of it. Also, one of the major benefits and one of the reasons I created the program initially is it allows you as a parent or as a grandparent to encourage children or grandchildren to get their estates planned, because the first $300 of legal fees for preparing their estates is covered by your Access benefit or your Access program. And that does not reduce your benefits at all. One of the things I want to mention about the Access program is we had intended to increase the fees for the Access program from $3,500 for a lifetime membership to $4,500. Because of the economic panic, we're going to maintain the old level of $3,500 for a lifetime membership. As you can see, the economic benefits of this program to you may be substantial depending on your individual circumstances. If you have an interest in the Access program, be sure and call Chelsea at our office at 1-800-244-8814. Again, that's Chelsea at Copenbarger Copenbarger, 1-800-244-8814. Thank you.